Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Richard Casey, partner at Robinson and Casey. Richard focuses on helping families navigate legal options when addiction or serious mental illness creates an urgent safety concern. His work includes Marchment Act cases, mental health guardianships, and advocacy around treatment access and oversight. I'm Lisa Mosby, and today we are talking about when addiction or mental health issues cross the line into legal emergencies and how families can recognize that moment when it happens. Welcome, Richard. Thank you so much for being with me.
Thank you. Thank you for having me.
Richard, when families are living through addiction or serious mental health challenges, what does a legal emergency actually mean in that context?
So when families are suffering from addiction or mental illness and have crisis with one of their loved ones, a legal emergency is probably not the first word that jumps to their mind. I kind of like to look at it as that they have a crisis, they have an emergency, and there happens to be a available legal solution. And so what we would look at is this entire pie, when we're talking about the patient at the center, when we're talking about where on that wheel, right, are they supposed to look for help? And there are different services inside that wheel. There are detox facilities, there are long-term residential treatment programs, there's your regular therapist down the street who does outpatient sessions. There's also a small sliver on there, which involves law firms, legal services. And so when a situation is escalated to the point of an emergency, one of the available options is to seek help legally. What can be done that we can get my loved one into treatment that respects their rights, right? That's done legally, but also has some version of enforceability, some type of consequence. And so we don't want that to be highly negative, but we also don't want to let our loved ones suffer unnecessarily without being able to step in and help. So really the degree of crisis is if they have a condition that's repetitive, that ultimately is not subsiding or going away, and they're unwilling to get help for themselves. One of the best things that we can do for them is put the type of guardrails that a legal solution offers in place for them. We would pick them up and we would put them in the path to recovery. We'd put some guardrails around that path, and we wouldn't monitor every step. We would ultimately protect them from falling off the path and into the gutter.
And that makes sense. What are some of the warning signs based on your experience? What are some of the warning signs that tell you a situation may have moved beyond something a family can manage on their own?
I think that certain families um, are working in a system of their own family origin. And so they may have blinders on to how serious some of these behaviors are. But if their life is starting to be impacted and they have some socially dysfunctional behaviors, they might be going through a divorce that's sparked because of their substance use. They may be crashing their car more often. They may be disappearing without giving anybody notice for long periods of time, right? They may be suffering employment disruptions. They might be homeless if it's an extreme scenario. But when I'm thinking of even like an adult child who once had their life together, that's ultimately starting to show signs that their world is not progressing as a result of their substance use. Their drinking is escalating. It's becoming more frequent. It's starting earlier during the day. It's preventing them from advancing their own life. There's difficulty with their children or their spouse. They may not be engaged in a more long-term relationship, and there might be difficulties with their parents. There's the need for extra money. Family members are continuously needing to support them financially without seeing the progression or growth that one would expect from their trajectory in life. Those types of behaviors are all indications that likely substances are starting to escalate and become a bigger part of their day-to-day life, and that they are not prioritizing the things that they need to. That doesn't mean that it's right time for a Marchment Act, but it is the warning signs that we're going to be looking at to say, how serious is their substance use? And when they've been to treatment before and they're not following the recommendations of staying abstinent, they're not going to their AA meetings, they're continuing to fall back into old patterns of substance misuse or a dependency, going to start to look at what type of action is the family going to take in order to change the results. Because if we continue to behave the same way, we're not going to get any different results.
So once they've decided that they're seeing things, their observations are confirming the situation is at hand, many families struggle with the timing. How do you think about the difference between acting too early versus waiting too long? How do they make that decision?
I really don't think there's ever a too early at a time period where you can express your concern and love for your family member. I think that strong boundaries are something that is learned and something that's most families weren't trained to have, but are something that they should be seeking right away. If they're capable of achieving those strong boundaries on their own, they may start to see their loved one move towards recovery faster. Those types of things include not supporting them financially, ultimately reducing their access to things that, for instance, if they have a grandchild that they really want to spend time with. Well, there's no reward of the grandchild if we can't get abstinence, right? So we're not going to be entrusting their grandchild to a parent or a grandparent who's not capable of maintaining their own substance use when they're supposed to be abstinent. So we would set these boundaries so that there's a consequence to their use or misuse. So there's no too early, in my opinion. We, I think, as a society, tend to either minimize or tolerate far more misbehavior in the substance use category than we should. And I think a lot of that is done really just out of love. They don't want to lose their loved one. They want to maintain their relationship, and out of fear. They don't know what steps to take that will actually be effective. And so they're just worried about if they do X, whatever X is, will they lose the love of their loved one? And so I think there's never too early to take action, although there is a requirement that the individual seeking help for their loved one does take steps to improve themselves first.
And then what about safety concerns? How does that factor into some of these decisions with legal intervention? When is it appropriate? Again, that too early, too late idea could play a factor here as well.
Yeah, I mean, obviously, safety concerns are of the utmost importance across this whole spectrum, right? So we're actually talking about safety the entire time we're talking about legal interventions. We're talking about the Marchment Act. We're talking about guardianships. We're talking about emergency responses for the Baker Act. And so ultimately, we want to make sure that the patient is not only safe during the enactment of the legal intervention, but stay safe, because what if we don't take action for the legal intervention and their safety is compromised that way? So when it comes to the legal intervention and how we would navigate that, we'll always be recommending that our clients work with some type of professional on site for a pickup. It's their choice whether that they themselves want to be on site or not, and whether they want to retain that separate support system. But we usually recommend former law enforcement to be on scene if there's ever a transport needed. And then current law enforcement would come simultaneously. And then that way we can ensure that there's a conducive dialogue between these two professionals about the way that transport should be done appropriately from their home or from their residence at that moment to a treatment facility. So we're looking to work with professionals who understand the needs of safety, and that's going to be a priority. But our thought is that the bigger issue of safety is primarily, if I don't act, if I wait too long, how do I negatively impact their safety as a whole? And so we really, we know that this is an emotional process. We know that this is not necessarily easy to take on, especially if you aren't as fully aware of all the steps that might be included with going forward with something like the Marchment Act. Um, and those types of legal interventions. But if we do nothing, the results are going to be the same, right? Nothing.
Let's talk about those specific actions. Can you maybe share a story without identifying details that would illustrate what it looks like when a family reaches that legal emergency point and what changed or what steps should they take? Do you have a story that where you could apply this and share a real life incident?
Yeah, obviously I can't share direct client information, but I can tell you that there are several different types of stories. Happy to share a few. But there's really similar types of stories. There are um, adult children where their parents are trying to petition the Marchment Act, and that they could be even 17, but usually like 18 to 30, and they're in a particular stage of their life. There are the opposite. There are people who are in their 40s and 50s, and their spouse is involved. And then there are sometimes people who are on their 60s and 70s, and their adult children are the petitioner. And so each situation and everybody's personal circumstances are a little bit different. So we might see someone who's been drinking their whole life and has gotten to the 60s and they haven't necessarily had any issues with drugs. They might have dabbled here or there. There may be serious issue with drugs, but for the most part, the person that I'm thinking of is primarily just a drinker, right? And so their health is starting to decline. Years and years of continuous compounding alcohol abuse is going to deteriorate not only your liver, but it's also going to start impacting your mental health from the ability of cognitive reasoning and your ability to understand everything that's going on. And these might be extremely successful, extremely intelligent, extremely capable individuals who have really built amazing worlds for themselves and their families. So now their adult children are left. Maybe the divorce has already come and gone years ago, and the adult children are left. And you have dad who is wealthy and who is willing to remove your entire inheritance, right? If you dare challenge him about what he knows is best for himself. Every type of plea, love sharing, letter writing, or attempt to get dad to see his condition as significant, and ultimately the risk of losing him in perpetuity now, or taking a shot and having it not work, or taking a shot and having him get sober but disinherit you, are all of these compounding issues. So what do you do? What does an adult child do in that scenario? And we recommend that they proceed with the Marchment Act. And there's a good reason. Now, other times a guardianship might be appropriate if it's not alcohol, but it's mental illness. But we recommend that you proceed with the Marchment Act because ultimately the situation is not going to improve. Your loved one is going to deteriorate. If they are going to continue to drink themselves to death, they're not going to become happier with you. They're not going to ultimately say, you know, I would love to make sure that you maintain your inheritance and I'm going to go get sober myself. That's not going to happen unless there's a consequence, right? So the ultimate consequence that you're essentially manufacturing with the Marchment Act is you must go to treatment. This is the consequence. It is a shock to the system, yes. And yes, the family member is the one initiating it. But it's hopefully a light bulb in the man's eyes or the woman's eyes, right? But in this story, a dad, that he needs more than a new liver transplant. He needs to actually discontinue his alcohol abuse. And so you have these kind of conditions escalating. The opposite is that mom and dad have been trying to get little Johnny help for years. And maybe Johnny was going to treatment at 16 because things were not always great. Or maybe they just started at 19 when he first went to college. But ultimately it's 5, 6, 7 years later. And Johnny really just wants mom and dad to stop making him, go to treatment because he wants to live his life. But he doesn't understand that he's continuing to sabotage his own world each time he goes to treatment, leaves, and then returns to doing drugs and alcohol. And the consequences of how that impacts his mind. We see too many people with cannabis-induced psychosis where they're just smoking marijuana, but ultimately they start to have these delusional thoughts. They start to share these paranoid beliefs. They start to communicate that there are famous people or other types of like impossibilities, right, going on in their world, that they're dating somebody that we would all know in pop culture, or that this person called them on the phone, but that person's not calling them on the phone. They're a famous politician, or right, there are these kind of delusional thoughts that we know are not true, and there's no evidence for them, and they hold on to them, but they're just smoking marijuana. And we their family gets them to treatment, and they stay in treatment for a limited period of time, and their delusions deteriorate, and ultimately they go back to having a little bit clearer thinking, and they think, I can go back to smoking marijuana, and right back to it they go. Now it's 6 years down the road. They no longer want mom and dad to control them, and mom and dad are worried. um, Mom and dad are worried that they're going to be controlling them. And so they ultimately are apprehensive to move forward with the Marchment Act. But they cannot get little Johnny to stay in treatment for the year it might take for his mind to truly heal and get to the point of understanding the significant impact his cannabis abuse could provide to him. And so we struggle with these families holding boundaries long enough on their own when things seem to be a little bit better and there's a little bit more manipulation from the patient and they are able to show things. And the clinical team is recommending a longer period, and Johnny cuts the clinical team off from mom and dad, so they too can't talk to each other anymore, and they don't know what the recommendation really is. And so that Johnny can control the outcome and ultimately discontinue going to treatment and tell mom and dad, I completed treatment. See, I did the 30-day residential. I did the 30-day partial hospitalization afterwards, but I didn't need anything else. I need to go back to my old life. And so when you're in this pattern of 6 years of trying to, or even if it's 2 or 3 years, or even if it's 10 or 15 years, when you're in this pattern of having the patient repeat the same behavior over and over, and they become sophisticated and understanding how to limit access of information or manipulate the family to funding their well-being and their lifestyle, or to let them discontinue treatment, it becomes appropriate to put those guardrails, to put those bumpers in place so that we can get the length of time.
Richard, how do we help people see this type of legal action as an act of care rather than punishment?
I never have seen it as punishment. I'm pretty open about my own story. Um, and In my own story, there were people in my life who had sought to commit me to treatment. And they were unaware of the Marchment Act when I was going through this. And let me tell you, they would have been the largest advocates of saving my life via this method. And so I get the perspective of being the patient as well as being the person who's helping families with this. So it's really important to me not to see it as a punishment. The the evidence shows that there is no statistically significant difference between court ordered treatment and voluntary treatment. There's this fallacy that there's this opinion out there that it only works if they do the work and they want it. And so if they're not willing to go themselves, let them crash and burn, and wait until they crash and burn. But if the evidence shows that the chances of success are the same for the person who willingly walks in the door to treatment as the person who's court ordered to go to treatment, why would I wait? I have the same chance of success. If I wait, my chances are nothing. They're not getting treatment. If I send them to treatment and compassionately end their suffering sooner, I have the exact same chance of going forward with success. A different study shows that the best chances of success, or that the chances of success improve the most based upon length of time in treatment. The longer they engage with the treatment process. And if they're willing to walk in voluntarily, but only willing to stay a month, their odds are going to be worse than if they are court ordered treatment, but are required to stay 90 days. I'm not punishing an individual for their suffering with a disease. I'm taking a person who's cognitively incapable of understanding how bad their disease is and how much treatment they actually need, and putting them in a system of care which feeds them, provides them dignity, right? Puts them in an environment that's similar to their own home-like environment. No, it's not their home, right? But these are clean, well-maintained, cared for, right? The Marchment Act allows us to pick private treatment environments. These aren't run-down hospitals. These are the best of the best available to anyone in the world, the same places that the voluntary patient is walking in themselves. And so it's not a punishment. They want to categorize the people putting them there as their perpetrator. And the best way to do that is to try to categorically denounce it as a punishment so that they can view themselves as the victim of their circumstances. But really, the family is creating the opportunity of a lifetime. And it's really just a matter of perspective, because the facility didn't change from when it was voluntary to when it was involuntary. The food didn't change from when it was voluntary and involuntary. I didn't put bars on the windows because I ordered them to treatment. The bed is still the same bed. The mattress is still the same mattress. The pillow is still the same pillow. The housekeeper that comes and cleans your room is still the same housekeeper that comes and cleans your room. And I'm sure that they don't have that currently going on in their home environment. So it's not a punishment when it's exactly the same as what people are paying to go to. It's just that the perspective of the patient and sometimes the family is that this is going to be something that they won't like, because they'd have to change the way they behave. And it's really just the opportunity of a lifetime.
It sounds like it. And I think we'll leave it there for this week's episode. You know, folks, that's it for today's episode of A Way Forward, The Right to Recover. If you'd like to learn more about Richard and the work of Robinson and Casey, including resources related to the Marchment Act and mental health guardianship in Florida, please visit robinsoncasey.com. Thanks for listening. And don't forget to like, leave a review, and please share this episode with someone who could use it today. Come on back next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.